few words. We just wanted to make sure those on the call knew about the origins of AB 1482. But I'll make it a short origin story. So again, I'm the statewide campaign director for the community group ACE. This call is being hosted by Housing Now, which is a statewide coalition. The steering committee for Housing Now includes ACE, Pico, California, Inner City Law Center, Public Counsel, Public Advocates, SEIU California, LA Tenants Union, San Francisco Tenants Union, Leadership Council for Leadership and Accountability in the Central Valley, MH Action, which is Mobile Home Action, a state national network of mobile home tenants or homeowners. And I might have missed a person or two, but this statewide coalition has 90 members, organizational members roughly. And over the last couple of years has been bringing together not just tenants' rights groups and community groups, but also unions, policy folks, and some less likely suspects, but people who care about housing and housing for particularly low-income communities of color or housing affordable for everybody. And we've been waging a multi-year campaign to both extend tenant protections and secure more funding for housing, particularly for people at the low income, very low income levels. And to combat exclusionary zoning, we have a multi-pronged agenda. Anyway, Housing Now plus others like California YIMBY and Tech Equity and the 3Ps Coalition up in the Bay Area, and many, many folks, California Federation of Labor, moved this campaign to win AB 1482. It was an enormous fight. We feel like we used lots of different tools and tactics and strategies to push it through. It started out being much more robust than it ended up being. We had to make compromises along the way, but we all had decided that, particularly in this time of tremendous crisis for our communities, winning some protections for millions is better than no protections, and holding out for perfection. So that was the thinking, but we know the fight continues. This is just the beginning, or a next step rather, in expanding protections for our communities. So welcome to this webinar. If Kimberly is on and can unmute herself, she's going to say a few words on behalf of SEIU California.
Thank you so much, Amy. As she mentioned, I'm with SEIU California. We are a 700,000 member organization throughout California. We have 17 locals, so we're a very member-driven organization, and our involvement with Housing Now and with housing issues overall started, as it always does, with our members engaging at the local level. So a number of the locals are also members of the coalition, which kind of drove us to join on the steering committee. I think kind of understanding where SEIU is coming from is helpful to know a little bit of background about ourselves. As I mentioned, we have 1,000 members, but we do everything from county work, state employees, to in-home supportive service workers, janitors, property service members, and classified workers in the school. And every single one of our locals has listed housing and homelessness as a concern. We have members that are in-home supportive service workers that not only is having affordable rent important for them, but also their employer, because they serve workers in their home. So as I mentioned, it was a growing issue. We dipped our toe in with the Costa-Hawkins bill a few years back, and the overwhelming engagement by our membership indicated that housing was something that we wanted to weigh in more. And so we joined our advocates, such as Western Center, Housing Now, to kind of help elevate 1482 from the start. And we knew that not only was it important to keep our members in our home through having just cause protections, but also starting to equalize the playing field on how much rent was growing, because this is an issue that we see at the bargaining table, where the cost of housing and the cost of rent was outpacing anything we could negotiate in wage increases. And as Amy mentioned, it's not the product we started with, but it's so important where we ended up, and having those protections in place so that we can continue to grow and advocate for our members while knowing that we have some things we're able to help our members stay in their home. And I think 1482 was a huge effort of collaboration. And we were really happy to participate kind of as a people power. Our workers not only were engaged at the state level, showing up, in committee hearings, but were able to do local engagement. So, we're all over California. We could send them out to the different legislators and let them know and hear directly member stories about the difficulty of staying in their home and cost. And so that was our role in a contribution towards 1482, and also helping lend kind of the personal voice to it. And I think the way we were successful in AB 1482 was just the huge coalition and engagement we had at every single level. But also, I think we were really happy as labor to join in and kind of give a different perspective of labor as the workers that are struggling to stay in their homes despite having optically good middle-class jobs. And then also just our workers that have public sector work and are facing homelessness because of the rising cost. And that's why SEIU has, over the last few years, continued to increase our engagement in housing and in legislation to protect tenants. So I think that's kind of our overview of our role and how we saw 1482. I definitely think it's a jumping off point, but I'm happy to answer any questions or, if Amy wants me to chime in on any other portions, I'm happy to.
Thank you so much, Kimberly. Francisco, I think now we turn it over to Brian.
Okay. Can you all hear me?
Yes.
Great. We're having a little bit of technical difficulty, but for example, I'm not able to actually get in to see the webinar as it runs, but I want to make sure that others can see a screen that's showing a PowerPoint.
Yep, I can.
Okay, good. So we're going to work through this. Sasha's going to advance the slides as I talk, and so let's get going because we have a lot to cover. And what we would like to do in this portion of the webinar is walk everyone through what the law is and what it does. And then we're going to talk a little bit about, at the end, some of the implementation issues that are coming up already and some of the next steps that we want to do in that regard. And so between me and Sasha with Western Center on Law and Poverty, we're going to sort of tag team this presentation. So we will hopefully have time for some questions at the end, and you can use the chat feature on the webinar to submit your questions, and then Francisco will take those and convey them, and we'll try to answer them. Okay, so let's go. Tenant Protection Act of 2019, AB 1482. Next slide, let's just do a brief overview of what it does. We'll get into some detail here, but it has a rent cap of 5% plus CPI annually, so no more than increase of that amount up to a maximum of 10%, and also establishes just cause for termination of tenancy for any tenant who has been there at least 12 months. There are a number of exclusions and exceptions. Certain categories of units are excluded. We're going to talk in detail about that in this presentation. In fact,
Brian,
let's go to the next slide.
And Sasha,
yes?
I'm sorry, the slides aren't moving. Sasha, I don't know if you can, in fact, move the slides, but they're not moving on our screen.
You're still on the first.
Let's go to the second slide. What units are covered by the law? Or the third slide, probably. Are you there?
No, they're not moving. Well, as folks are asking us if we are going to share this PowerPoint afterwards, and the answer is absolutely yes. So while they try to figure that out, I suggest you keep going, Brian.
Okay.
Oh, it's working now. Thank you.
Okay. Okay.
What
so,
units are covered by the law? I'll narrate
great.
for you. Okay.
Technology.
What units are covered by the law?
Okay. So very important place to start because we, at the state level, the legislature is able to cover units under a rent cap, state rent cap, that locals could not cover because of just cause. So that's a theme that we're going to talk about throughout. So everyone who's familiar with their local rent control ordinance may be confused about the intersection between what single family homes are covered or newer construction. We're going to talk about that. We're adding another layer too, because there's some exceptions in this law that are maybe a little bit different than what exists under your local ordinance. So let's get into that. This covers all rental units in the state except the following. The biggest exclusion is single family homes, except those that are owned or controlled by a corporation. So if it's owned by Blackstone or an LLC that's controlled by Blackstone, it is covered by AB 1482. The law also exempts all units covered by a local rent control ordinance that is lower than the cap. So in most cities with an existing local rent control ordinance, the units that are covered by the local rent control ordinance are not covered by 1482. They're covered by your local ordinance. One thing that differs a lot from at the local level is that we have a new construction exemption in this bill as well, but it's only a 15-year new construction exemption, and it's a rolling exemption. So at the moment, every unit that was constructed in the past 15 years is excluded, but anything older than that is covered. We exclude mobile homes. We exclude duplexes in which the owner lives in one of the units, but the owner has to be living there when they rent the unit, and if they move out, then both units are covered by 1482. And then affordable housing that's subject to a deed restriction is not covered, or some other regulatory agreement, and dormitories. Let's go to the next slide. There are a few things that are different in terms of exceptions between the rent cap and the just cause. And this is an issue that we hope to clean up later, but there are additional category of units that are exempt only from the just cause portion of 1482, which is a bit of a anomaly that results from there being two separate bills that then got merged, and not all the exceptions merged together. There's some probably non-consequential ones like hospitals and hotels, but then as you'll see, there's housing accommodations in which the tenant shares a bathroom or kitchen, and then single-family owner-occupied residence in which the owner-occupant rents 2 or fewer rooms or units in that single-family home. And then ADUs are also exempt under this bill. So I'm sure there will be questions, and we're going to cover this a little bit more later, but those are the units that are not covered by the law. Everything else in the state is covered. So let's move to the next slide and start talking about the specifics of the rent cap. Sasha?
Yep. So, as you all know, one of the main features of this bill is to cap rent increases. And what the cap is 5% plus the regional CPI, if there is one for the region, and if there is not a regional CPI, there's an alternative, which is a statewide CPI.
Sasha, if we can hear you, but if you could be closer to a mic, it would be better.
Okay.
But keep going. That's much better. It's always better not to be on speaker.
That shakes out to equal about 8 or 9% in most regions, but there is an overall cap of 10% in the law because the CPI fluctuates from year to year, and that's just to make sure that it never goes over 10%. The rent increases, unlike I think most local rent control laws where there's one shot to raise the rent each year, the Tenant Protection Act provides that this can be done over 2 rent increases, so it doesn't have to be done all at once. But the rent increase needs to be based on the lowest amount charged during that calendar year. So it's not that they can do an increase over the increase. It all has to be based on the sort of the starting point for the year in terms of the rent. Importantly, this excludes discounts and things like that. Sometimes there's a first month free or something like that that a landlord provides as an incentive for somebody to move in. So this cap only applies to the gross rent, which has to be listed in the lease. So it's not that an owner can later claim, oh, I was giving you a discount and really, I'm raising your rent more. That has to all be sort of agreed upon and listed in the rental agreement. And then this does not change Costa Hawkins, so the vacancy decontrol still applies. If a tenant moves out, the initial rate for the rent can be set for the next tenant. But that's only when the entire household moves out. So sometimes we have, somebody leave a unit and a new roommate come in. That is not affected. The rent cap is not affected by that. The way to calculate the annual increase, we've included a link here where you can go to the state website that lists out the CPI. There's an Excel spreadsheet that you can download, and then there are some drop-down menus, and we'll show you an example of it in a second. Essentially, you go and download this tool, and you can select the time period that you're looking for, and the region that you're looking at, and then it will generate a number that is the CPI, or the change in CPI, over the year. And then you simply add the 5% to that to see the maximum allowable increase for that region. So this is what that website looks like, just so you can see it. What the law says is that this is going to be based off of April to April, so that's for most regions what you'll want to be looking at. Some regions are published in March, so depending on the region, you might be looking at April or March.
All right, so that's the rent cap. Let's talk about some of the details of just cause. Let's go to the first slide. There's two kinds of cause under this just cause law. There's at fault, where the tenant is at fault, and then there are categories of no fault just cause. So let's go to the next slide and talk about at fault just cause. There are a number of categories that constitute at fault just cause. The biggest is any category of action by a tenant that is currently covered under state law, under the code provisions that cover things like failing to pay the rent or breaching the lease, which is Code of Civil Procedure Section 1161. So those would be familiar to all of you. It includes non-payment of rent, breach of the lease, creating a nuisance, creating, quote, waste, or using the premises for unlawful purposes. Basically the basis for a 3-day notice to quit, or to cure or quit, or to pay or quit. So any of those are considered just cause. Then there's a few additional criminal activity on the premises, which arguably is already covered. We pushed hard to ensure that criminal activity off the premises wasn't pushed in there. One thing that we did sort of have to agree to is if there was criminal activity off the premises that was directed at the owner or agent, so the person who assaults the manager at the offsite leasing office, for example, that would be covered. Then there's refusal to allow lawful entry. So if the landlord is entitled to come in under sections that allow them to come in for needed repairs or checking smoke detectors, and don't assume that they have a right to come in. But if they do have a right to come in and the tenant repeatedly refuses that, that is a basis. And then refusal to execute a new lease on terms that are similar to the lease that the tenant currently has can also be the basis for that. And then let's go to the next slide and talk about no fault just cause. So this is a situation where the tenant hasn't done anything wrong, but it's still just cause. And this is a feature in local ordinances as well, but that includes owner move-in. So if the owner or it's his or her family members, parents, grandparents are moving into the unit, that can be the basis for a no-cause eviction or no-fault eviction. Substantial rehab, and I cut it out of the slide because it was very long, but there's a long definition of substantial rehab in the law that I think puts some important guardrails around what is substantial rehab that folks should take a look at. But it basically is something that can't be accomplished with the tenant in place. So that is included. Then the owner complying with any of the following: an order issued by a governmental agency or that requires, like such as habitability, that requires the property be vacated, or a local ordinance that might require the property to be vacated, an intention to demolish the unit, and then of course the Ellis Act. Those are all no fault, just cause. We'll talk about some differences in terms of eviction in that regard. But one important thing is that at fault, just cause, or I'm sorry, no fault, just cause requires relocation. It's not very robust. It's essentially 1 month's worth of rent, of the tenant's rent, which could include waiving the final month's rent rather than an actual cash payment to the tenant. But if there's a more robust local relocation, that applies, but it's not on top of it. So if the local ordinance requires 4 months of relocation plus other expenses, it's not 5 months, it's still just 4 months. If there's no local relocation, then the state 1 month relocation applies. Going to the next slide, what notice is required? In most cases where it's an at-fault that requires a 3-day notice under existing law, like non-payment of rent, it's going to be a 3-day notice. But then there's a provision that says if they don't cure in that 3 days, then they get another 3-day non-curable notice. And after that expires, if the tenant hasn't moved out, then it would proceed to an unlawful retainer, where of course the tenant would have whatever defenses they may have. In all other cases, it's a 30 or 60-day notice. So in all no-fault eviction proceedings, it would be 30, or if the tenant's been there at least a year, 60 days notice. And arguably on the issues of like not allowing the owner to come in for needed repairs, if that was a basis, that is arguably also a 30 or 60-day notice. Okay, let me hand it back to you, Sasha, for the next slide.
Okay. So one of the things that was agreed to in the process of getting this bill through was that the just cause protections don't, excuse me, don't immediately kick in for every tenant. So there's essentially a 12-month grace period after a tenant moves in before the just cause protections kick in. And then it gets a little bit more complicated. Importantly, if somebody has already been there for 12 months when the law kicks in, it's not, this is not 12 months from the effective date of the Tenant Protection Act. This is 12 months of living there. So if somebody has already lived there for a year or more when the law takes effect, they will immediately have just cause protections applied to their tenancy. There is a provision in the law that says that if a new tenant moves in, a new adult tenant, essentially that grace period resets until somebody has been there at least 2 years. So if there's a tenancy where everybody has lived there for 2 years or more, and then a new roommate kicks in, they will still be under the just cause protections. But if somebody has only lived there for 12 months, and so they now have the protections, but then a new adult roommate moves in a month later or something, it basically resets the clock until somebody has been there for 2 years. Oh, and I'm sorry, I missed a slide on all of that. So this just lays that out a little bit more clearly probably than what I said. So moving on to what happens between now and January 1st. January 1st, 2020 is when the Tenant Protection Act actually legally takes effect. And we've been seeing, some activity both in terms of rent increases and in terms of evictions leading up to that. And so we want to make sure that we go over sort of how those are or aren't affected by the TPA. So starting with rent increases, any rent increase that was issued before March 15th of this year is not affected by the Tenant Protection Act. The law was written in a way so that it retroactively will apply to any increases given after that once it does take effect. So rent increases that were given after March 15th, but obviously before January 1st, may be valid when they are given, but the key thing with those is that if they exceed the allowable cap under the Tenant Protection Act, once that law takes effect, those rent increases will essentially be rolled back. And the way that that works is that they will be adjusted back to whatever the rent was before that rent increase was given, plus the maximum allowable increase under the TPA. So the rent won't go back to what it was before, it'll go back to what it was before plus the allowable cap. One important thing to note is that it's not that tenants get a credit for any sort of quote-unquote excess rent that they paid before January 1st, but at least their rent will go back down to whatever is allowed under this law starting on that day. Evictions are a little less clear and are not as well addressed by the law. It just sort of legally wasn't possible to do the same sort of retroactivity type stuff on the eviction front. So the just cause protections don't kick in for any tenants under the Tenant Protection Act until January 1st, 2020. But it's really important to think about what other protections may apply to a tenancy if you see people getting evictions leading up to this law taking effect, which includes thinking through whether any local just cause laws may apply, whether there are, affordable housing or subsidy requirements. Sometimes those have not as strong a just cause requirement, but sometimes there is a requirement that a landlord, if they're getting subsidies, that they give some sort of just cause to their tenants, even if that's just saying, I'm evicting you for business reasons. It's important to look carefully at notices and try to latch on to any protections the tenant may have. There are also some price gouging restrictions currently in the law in areas where a disaster declaration has been made, and that's really important if you're working in one of the areas affected by the recent fires. There is a penal code section that limits rent increases and evictions while the disaster declaration is in effect. So if that applies and you're seeing that, maybe reach out for more information. We're still working through some of the legal theories around how to push back on evictions before January 1st, and we're definitely sort of continuing to research and develop some resources around that. I think the other really important thing in fighting back against evictions, especially when we're seeing entire buildings being cleared, is one, to think about who is being evicted. And if landlords are targeting a specific class of tenants, thinking through our existing anti-discrimination laws and using those to fight back. If landlords are targeting, a protected class, that should already not be allowed under fair housing laws. The other key thing I think, in dealing with these mass evictions is just sort of traditional tenant organizing. We're very excited about the TPA and all of the tools that it gives us, but it's also important, just to note that traditional tenant organizing, I know we've heard a lot of examples of really successful campaigns to push back against entire buildings being cleared, and things like that. And related to that, I think, is the idea of passing an urgency ordinance. So there are several cities, and forgive me, I had a list that I failed to bring with me, but I know Los Angeles, I think Milpitas, Redwood City, and Daly City very recently, some cities in Marin. There's been a lot of momentum and a lot of success in passing urgency ordinances locally in cities that say, until this law takes effect, given the housing crisis, we are basically placing a moratorium on no-fault evictions. So giving folks those just cause protections right now to make sure that landlords can't game the system and clear cities out, or clear buildings out. And I want to pause there and just give an opportunity for Amy or Francisco to say a word on sort of organizing and those urgency ordinances, because I know it's been really exciting to see what's happening.
Great, thanks, Sasha. I think it's me because the call was maxed out. Those of you who got on are the lucky ones. We're going to need to schedule another one because there's clearly tremendous interest, and we're also going to do one in Spanish. But on the moratoriums, I'm based in LA, although I work statewide, and it was incredible to see both how quickly the city council was ready to move on their emergency moratorium on the 60-day notice evictions, and how quickly we as a housing justice community were able to mobilize to push it forward. So it passed, it's in effect, and we and Tenants Together and some other groups and individuals have created quite a few tools to help encourage cities and counties across the state to do this. So the window is closing soon in terms of, the time of year. We're getting close to January, but we have a template ordinance. We and lawyers who are ready to help, on the legal questions around local moratoria. And we have other, we have a letter for tenants that they can give to their landlords and property managers to make sure they know what's going on. Anyway, we have a set of materials. So, Sasha, just so I know, should I go into all the sort of materials we're going to make available post this call, or are you done or not? I wasn't sure.
No, not yet.
Was this your last slide? Okay, let me turn it back to you. Perfect. Okay.
Okay, great. And one just last thing I wanted to say about that, it has been amazing to see where these ordinances are getting passed. It is not just in sort of traditionally tenant-friendly places. I mean, we're seeing this successfully being done in cities where traditionally there really hasn't been a lot of love for tenants. So that's very exciting, and much credit to the organizers for getting that done. Now we want to get into a little bit the interaction between the Tenant Protection Act and local ordinances more generally in terms of local rent control laws, local just cause eviction, and I will turn it to Brian for that piece.
Okay, great. And I am now finally able to see what's being shown on the screen. So let's go to the next slide. We're going to cover sort of three categories of things, but as I mentioned earlier, I want to drill down a little bit on this question of the intersection between this state law and local just cause and rent control protections. One source of complication or confusion is Costa-Hawkins, which I know everyone knows, but Costa-Hawkins is the state law that puts limits on local rent control policies, including mandating vacancy control and excluding single-family homes and condos and freezing the new construction date at 1995 and earlier. All of those rules still apply. So nothing in 1482 gives new authority to local governments to expand their existing or new rent control laws. So if a local city wants to adopt a new rent control law, they're still subject to Costa-Hawkins. So there's a whole bunch of units that they can't cover, for example. And those units, however, are covered by, not all of them, but some of them are covered by 1482, as I was walking us through earlier. Why? Because Costa-Hawkins is a limit on what local governments can do. It's not a limit on what the state can do. And someday we hope the state will repeal Costa-Hawkins, right? So the state legislature has the power to do that. So do the people if we go back to the ballot. But they also have the power to say, we're going to regulate in a different way using the state law, some of these units that aren't permitted to be covered by local ordinances. So that is an important thing to understand here in the intersection between these two laws. And just know that if a unit is not covered by the local rent control law, it still might be covered under the TPA. In fact, a lot of them will be. Let's go to the next slide. One of the more confusing pieces of this, though, is how 1482 intersects, not confusing, but complicated, is how the law intersects with respect to just cause protections. And there are, of course, some cities that have just cause ordinances in place, or perhaps like Sacramento have a new rent cap that includes the just cause provisions. And in the final negotiations that the governor's office was pushing, one of the things that the landlords were pushing for was some clarity around this question of which law applies. We wanted to ensure that we protected both existing ordinances, but also did not preclude adoption of new ordinances. And then third, that we didn't allow locals to adopt a crappy just cause ordinance and proclaim themselves excluded or preempted locally, preempt 1482. So in other words, sort of enact a local ordinance and get out of 1482. So we wanted to accomplish all three of those things. And so I think we've done that. So the important things to know here are, if any local just cause ordinance enacted on or before September 1st, 2019, that local law applies, not the just cause provisions of the TPA of 1482. If it's enacted after September 1st or amended after September 1st of this year, the local ordinance applies only if it is more protective. And so that there's some standards as to what that means, but it has to be consistent with the TPA. It has to further limit the reasons for eviction, so providing additional protections, provide higher relocation amounts, or provide additional tenant protections in addition to just cause protections. They have to make a finding that the ordinance is more protective, and at the local level. But that, by the way, that's an opportunity for advocacy if you think it's not. And then I'm skipping over that final bullet to just say, as it notes at the very bottom there, one thing to know is if there is a local just cause ordinance in place that is operative, that isn't, that's stronger than 1482, a tenant in a unit that's covered by that ordinance, you cannot be protected by both at the same time. So you are either covered by the local law, or if there's a local law and it is not more protective than 1482, it doesn't apply and the state law applies. But you can't sort of pick and choose pieces of 1482 and pieces of the local ordinance. It's one or the other. And finally, one thing to keep in mind, particularly from an organizing and advocacy standpoint, is that local just cause ordinance can cover more units than the TPA. And I know there's been some conversation in some jurisdictions, including LA, about expanding the just cause ordinance. Conceivably, such an ordinance could cover every unit. The TPA does not prevent that. And of course, Costa-Hawkins, which limits rent control, has no impact on just a purely just cause ordinance. So, so there are no limits on that. That's, I think, an important thing for people to understand. And I don't know if that's our last slide, if there's one more, Sasha.
End of slideshow.
All
So, yeah, back to you, Amy. I think we got a lot of questions in there.
Yes, thanks so much, Brian and Sasha. They were two of many folks. The folks that held it down in the Capitol also included Anya Waller at Western Center, Michelle Parasette with Public Advocates, our folks with SEIU, and the list goes on. But thanks. All right. Couple housekeeping things before we dive into the questions that people have been registering in the group chat. One is that, yes, this is being recorded, and we will be sharing both the recording and the slides. I don't know if we have everybody's emails, but the same listservs that we emailed to invite to this call, we'll make sure an email goes out with some of these materials. So those materials include the recording and the slides, but it will also include some other things like the template ordinance, probably an FAQ in English and Spanish, and a couple other things. We are all working to document abuses by landlords right now. We consider an abuse of the will of California, who passed this, to go ahead and evict people for no cause now. Even though legally they can do it if we don't pass the local moratorium. We also consider rent gouging wrong now, even though it's not illegal unless we can pass something to make that illegal, except for the 10% cap because of the governor's declaration around fire. But my point is that we're trying to document these tenant experiences. So we will share a Google Doc spreadsheet where we're capturing those. We are having ongoing conversations about implementation and enforcement. By we, I mean it's mostly Western Center and Housing Advocates and Brian who are convening those calls. There are policy and legal calls about implementation and enforcement. And then ACE and others and Housing Now are having organizing conversations because there's going to be likely a fight for state funding to help with implementation and enforcement. There's other conversations about the need for a statewide registry that could be a state bill next year to help with enforcement, et cetera. So folks should reach out to Brian or Sasha if they want to stay more involved or get more involved in conversations around implementation and enforcement. And always feel free to reach out to Francisco on the organizing side as one point person. His name is Francisco Duenas at Cal, so his email is fduenas, DUENAS at calorganize.org. That's the ACE email, calorganize.org. All right, let's go to some questions.
Amy, one question that I see coming up a lot on there is, if a no-cause notice is issued now, before the law takes effect, but expires after January 1st when the law takes effect, does the law apply if and when that case gets to court, which is a question that we have all been discussing. And I actually want to see if Madeline is still on and wants to hit *6.
Can you hear me?
And then she can see. Yep.
We can.
Okay, great.
You want to address that?
Yeah, so I think there's kind of two different ways that this comes up, right? So one is if the notice itself has not expired before January 1st, and I think that is, you have a strong argument for saying that you cannot proceed using a notice that doesn't state cause, because as of January 1st, this law is clearly in effect, and so the notice doesn't work. It does not terminate the tenancy, because the way that the eviction process generally works is that the tenancy is not terminated until the end of the notice period. So when you get the notice, it says, 60 days, and so the tenancy is still going until the end of that 60-day period. So if the end of that 60-day period is after January 1st, then you're in a good position to challenge any eviction action. It's a little bit more murky when you get to the point that the notice has expired before January 1st, but then the landlord goes ahead and files an unlawful detainer after January 1st. I think that's the situation that maybe a lot more people will find themselves in. And there are a lot of cases that talk about this issue and say that the landlord has to affirmatively plead that they have complied with all of the laws that are in effect. And so I think that you would, again, have an argument in the unlawful detainer in the court case where the landlord tries to evict the tenant. You would be able to argue that they can't do that without having stated cause and then notice. And then sort of on a larger issue of just the effective date of this law. So I think there's been a broad assumption, including by the authors and everyone, that the effective date of January 1st is the correct one. But I've been researching this issue, and I think that there is actually a pretty strong argument that the law was effective immediately upon passage because it just impacts the procedure that you use to evict someone. So we don't really have time to talk about that more in detail now, but I'm happy to speak separately with people about that.
And just so folks know, that was Madeline Howard with the Western Center on Law and Poverty.
And this is Sasha with Western Center. I just wanted to add one note. It's still important to make sure for each tenant that they've been there for the requisite amount of time for these just cause protections to kick in. But assuming that they have, then everything that Madeline said about, notices expiring after the effective date should hold true.
And just to add on,
we have 7 minutes. Yep,
okay.
Go ahead.
Just very briefly, this is Madeline again. I know we have lots of different folks on the phone. If you are not working in a legal services office and you're working with tenants who are getting these notices, it would be really great to get them into your local legal services program so that they could show the notices and work with the legal services attorney so they can get that kind of assistance, and then we can partner with those programs in order to hopefully stop the evictions. So.
Brian, did you have a next question you wanted to go to?
Well, I can't see all the other ones that came in early on, so maybe.
Cool. All right. So from Jorge Rivera with Tenants Together, is an LLC considered a corporation, or does the LLC have to be owned or operated by another corporation type? So this, if you want to answer by also explaining where this comes up.
Yeah. So, well, the short answer to that question is an LLC that owns a single family home. That's where this question is coming up. That's owned by individuals, controlled by individuals, would still be exempt. But if it is controlled by a corporation, and in the context of an LLC, we call those members. If one of the members is a corporation, like Blackstone were to go and set up a bunch of LLCs, the way we wrote it was that those LLCs would not be exempt. Was there more you thought we should say on that, Amy?
No, thank you. I'm scrolling down to see. There are questions about the criminal activity. Madeline started answering it on the chat. What defines criminal activity? And again, where does this come up in terms of implementing this law? Madeline, do you want to say a word on that?
Yeah, I think, as I said in my brief response, the law doesn't define what criminal activity is in this context, but that has come up in other cases because it comes up in like subsidized housing, and local ordinances talk about criminal activity. So I think you would sort of analogize to those scenarios. There are some general principles that apply. The one I pointed out is just that an arrest alone should not be used as a basis for an eviction. It can sort of be evidence that something happened that was criminal, but there's guidance from the Federal Department of Housing and Urban Development that says an arrest alone cannot be used as a basis for an eviction because it violates anti-discrimination laws as having a disparate impact on people of color. So that's like one general principle, and I think it's always going to just depend on like the specific facts and the evidence that the landlord has of criminal activity, but it's not specifically defined here.
And for those who haven't been tracking this, this is about criminal activity by the tenant on the premises. And the actual language from AB 1482 is in the group chat now. Yeah, go ahead.
I see one question about the look back date, so let's talk about that for a second because that will be important. March 15th, if the rent was increased after March 15th of this year to a level that exceeds what the rent cap provides for, so if that's 9% and they did a 20% rent increase, come January 1st, the rent for that unit, the lawful rent for that unit is whatever the rent had been on March 15th plus the additional amount that this law allows and nothing more. So one of the questions there was, do they need to recalculate their rents, or does the lease, do they have to wait till the lease expires? As of January 1st, that whatever the right rent is under that formula that I just described, that is the rent. It's not dependent on there being an existing lease, although we, I think, are seeing landlords executing new leases in hopes of avoiding that. But I don't know, Madeline, if you want to add more to that, but or Sasha, but the rent on that date is the rent that must be rolled back to that March 15th plus adjustment date. There is not any authority to get a refund of what was paid between March and January 1, however.
Right.
There more
so
there
no,
that you almost said?
Well, just to summarize, there's no sort of action that needs to be taken by the landlord. It just automatically is readjusted to that amount. So that's all a tenant will be legally obligated to pay.
But this won't happen unless tenants know about this and landlords hear about it and comply. So we really, there's a massive tenant education outreach program that needs to happen.
Mm-hmm.
One more question and then we'll wrap. How about properties owned by a trust? So again, this is going to the single family rentals, right?
Yeah, I just answered that in the chat, but the
sorry.
Generally, I just hit send. But generally, a trust property, so family trust, those are going to be exempt, unless I don't know if a corporation can establish hold those properties in trust. But if it was a corporation behind the trust, then arguably the exemption does not apply. But otherwise, family trust properties would be, or other forms of trust would be exempt.
Okay. One more announcement. I see lots of people are doing it. I indicated in the group chat that if you think you're not on a listserv and you want to make sure you're reading the materials, you can send me your email. So lots of people are putting their emails in the group chat, and we'll make sure you get the materials from this call. Brian, Sasha, Madeline, any last thing you'd like to say before we wrap up?
No. Thank you all for joining, and and for contributing.
Thank you all
questions.
so much. Yes, and we will. Housing Now has a monthly call, and it's a big coalition. If you want to join, reach out to us. We will be doing another one of these in English for people who weren't able to get on because we maxed out on lines. And we'll also be doing one in Spanish probably in the evening. Both of those will be within the next 2 weeks, but we have to schedule them. All right. Thanks, everybody. Thanks, Brian, Sasha, Madeline, and others.
Thank you.
Thank you.
Bye.
Thanks. Bye.